I'd ask that further proceedings under the quorum call be waived.
Without objection.
Thank you, Mr. President. And I would make a motion to proceed to S.J. Res. 36.
The clerk will report.
Motion to proceed to calendar number 361, S.J. Res. 36, joint resolution providing for congressional disapproval under Chapter 8 of Title 5, United States Code, of the rules submitted by the National Labor Relations Board relating to representation election procedures.
Under the previous order, there will be 2 hours of debate equally divided and controlled between the two leaders or their designees. The senator from Wyoming is recognized.
Thank you, Mr. President. And I rise today to ask for disapproval to stop the National Labor Relations Board's ambush election rule. This rule that I'm objecting to was rushed into place by a National Labor Relations Board that's bound and determined to stack the odds against the American employees and to put employers and to put employees in an unfair situation. Despite the fact that unemployment has remained above 8% for the past 3 years and small business growth is the most important factor in reversing the lackluster trend, the National Labor Relations Board has chosen to impose new rules to aid big labor at the expense of employees, particularly small business employers, and the jobs they would create. If the Senate does not act now to stop this rule by passing my resolution, it will go into effect on Monday, April 30th, just 10 months after it was first proposed. The changes that are being made are going to be a big surprise for the employers and employees that get caught in this net, particularly, as I mentioned, the small employers that do not have the human resource departments or the in-house counsel. I would expect that we, elected representatives of the people, are going to face a lot of questions about what we did to stop this blatant effort to stack the odds in big labor's favor. And we will be asked. This rule will shift the law significantly in favor of big labor. Let me take a moment to explain. Under current practice, there's a 25-day waiting period between the setting of an election by a hearing officer and the actual secret ballot election. Employers can use this time to familiarize themselves with the requirements and restrictions of the law. This is very important because there are many ways that an unknowledgeable employer with the best intentions could make a misstep that would be heavily penalized by the National Labor Relations Board. Employers also use the time to communicate with their employees about the decision they are making and correct misstatements and falsehoods that they may be hearing from union organizers. Parties also use this time to seek review of a decision made by a hearing officer or a National Labor Relations Board regional director. Under the new law, the new regulation, the 25-day waiting period is abolished, and employers may face an election in as few as 10 days. Is it fair to the employees to only have 10 days to learn how this will affect his or her life and how much his or her earned money this will cost? Under current law, both parties are able to raise issues about the election at a pre-election hearing, covering such issues as which employees should be included in the bargaining unit and whether particular employees are actually supervisors. Under the new regulation, parties will be barred from raising these questions until after the election. Employees will be forced to vote without knowing which other employees will actually be in the bargaining unit with them. This is important information that weighs heavily in most employees' vote. Additionally, because of the National Labor Relations Board's decision to allow micro-units, like specialty health care unions, the unions will essentially be granted any bargaining unit they design, and employers will have a very limited time to weigh in. Under current law, when either party raises pre-election issues, they're allowed to submit evidence and testimony and file post-hearing briefs for the hearing officer to consider, and have 14 days in which to appeal decisions made with respect to that election. Under the new regulation, a hearing officer is given the broad discretion to bar all evidence and testimony unrelated to the question of representation and all post-election briefs, and no appeals or requests for stays are allowed. This can be quite a disadvantage for employees as well. What this all adds up to is an extremely small window of time from filing a petition to the actual election. Little opportunity for employers to learn their rights or communicate with employees their rights. And less opportunity for employees to research the unions and the ramifications of forming a union. The NLRB is ensuring that the odds are stacked against employees and businesses. This vote's an opportunity to tell the NLRB to reverse course. If we pass this resolution, as I hope we will, the Senate will not be the only branch of government telling the NLRB it's off track. Last month, a District of Columbia federal court told the NLRB that several provisions of its notice posting regulation were well exceeding their authority and struck them down. This was a judge appointed by President Obama. 2 weeks ago, another federal court, this time in South Carolina, also ruled against the NLRB. It found that the entire notice posting regulation violated congressional intent. Following up on these two rulings, the D.C. Court of Appeals just stayed the entire rule until appeals are completed. The court in that case was frustrated that the NLRB did not postpone the rule itself, given the multiple negative treatments in the courts. Unfortunately, that reckless sense of blind mission is consistent with this administration's NLRB. It's kind of like Thelma and Louise driving off a cliff. Well, Mr. President, I, for one, do not want to see the NLRB drive our economy off a cliff. I hope this resolution will pull them back and encourage them to focus on their statutory mission. The National Labor Relations Board enforces the National Labor Relations Act, which is a carefully balanced law that protects the rights of employees to join or not join a union and also protects the right of employers to free speech and unrestricted flow of commerce. Since it was enacted in 1935, changes to this statute have been rare. When they have occurred, it's been the result of careful negotiations with stakeholders. This change is one-sided and super quick, an ambush to set up ambush elections. National Labor Relations Board is not an agency that typically issues regulations. Listen to this. In fact, over 75 years, the National Labor Relations Board has finalized only 3 regulations through formal rulemaking, 2 of which occurred last year. Let me repeat that. In over 75 years, National Labor Relations Board has finalized only 3 regulations through formal rulemaking, and 2 of them occurred just last year. This current National Labor Relations Board. As I mentioned, one of those was already struck down by one court and stayed by another. Most of the questions that come up under the law are handled through decisions of the board. Board decisions often do change the enforcement of the law significantly, but they're issued in response to the actual dispute and question of law. In contrast, the ambush election is not a response to a real problem because the current election process for certifying whether employees want to form a union is not broken. This rule was not carefully negotiated by stakeholders. Instead, it was rushed into place in over just 6 months, despite the fact that it drew over 65,000 comments in the 2-month period after it was first proposed. Labor law history provides an interesting contrast to this rushed regulatory approach. In the late 1950s, Congress became concerned about undemocratic practices, labor racketeering, and mob influence in certain labor unions. Excuse me. To address this, the Senate created a special committee, the Select Committee on Improper Activities in the Labor or Management Field. That operated for 3 years and heard more than 1,500 witnesses over 270 days of hearings. Based upon their investigations, the Senate negotiated and passed legislation to protect the rights of rank-and-file union members and employers. The legislation is known as the Landrum-Griffin Act. The issue of how long a period of time there should be between the request for an election and the actual election came up during those negotiations. My colleagues may be surprised to learn that it was Senator John F. Kennedy who argued vigorously for a 30-day waiting period prior to the election. As he said, quote, "There should be at least a 30-day interval between the request for an election and the holding of an election in which both parties can present their viewpoints. The 30-day waiting period is an additional safeguard against rushing employees into an election where they are unfamiliar with the issues." End quote, by John F. Kennedy. Fairness to the employees, that's what Senator John F. Kennedy was talking about. The 30-day waiting period provision he supported did not ultimately become part of the law, and obviously it's not the law today. Instead, the NLRB adopted a practice of a 25-day waiting period in almost every case. But this caution about the need for employees to have a chance to become familiar with the issues is just as true today. Employees who were not aware of the organizing activity at their work site, and even those who were, need to have an opportunity to learn about the union they may join. They'll want to research the union to ensure it has no signs of corruption. They'll want to know how other work sites have fared with this union and whether they can believe the promises the union organizers may be extending. Employees should have every chance to understand the impact of unionization. For example, they will no longer be able to negotiate a raise individually with their employer. Doing your job better than fellow employees may no longer bring any benefit whatsoever. Union rules may even hinder sales. Once had the opportunity to visit a shoe factory. I was in the retail shoe business, and we visited a shoe factory, and as we went through it, I saw some of the boxes of some of the shoes that we normally carry and was kind of interested in what the new fashion looked like, so I went over and I opened a box, and the roof caved in. Not really, but it seemed like the roof caved in because it has to be somebody that has union authority to be able to open that box, and it can't be the supervisor. So I actually shut down the factory for about 30 minutes just by picking up a box to look at what the shoes were in there that were probably going to be coming to my store at one point in time. Grievances cannot be brought straight to the employer, but they'll instead have to go through the filter of union management. Once a union is certified, the National Labor Relations Board has instituted significant restrictions for when it may be decertified. In other words, when the employees can fire a union as their representative. Employees are barred from petitioning for decertification for a full year after the election, and barred as well throughout the term of the collective bargaining agreement. So there really is a very small window in which employees have any opportunity to get rid of a union they do not support. They're going to be rushed into the judgment and then stuck with it. 4 decades ago, senators recognized that employees deserve the opportunity to gather this and all other relevant information before casting their vote. Unfortunately, the NLRB is choosing to ignore this caution, and rank-and-file employees will suffer. Fairness to the employee? This situation is exactly what the Congressional Review Act was intended for. When an agency takes regulatory action that's not supported by the people and their representatives, the Congressional Review Act gives Congress the chance to repeal that regulation. In this case, those advocating this are doing so because they cannot pass the bill they really want, which is card check. Now, card check is where you just have to have the people go in and stand over somebody's shoulder while they check a box that says they want to be in a union, and then with enough signatures or enough boxes checked, there is no secret ballot election. Many have referred to this as a backdoor card check. This particular NLRB regulation is a backdoor card check, and for good reason. Both proposals seek to restrict all communication with employees prior to a union election for union organizers only. Under both scenarios, employees are likely to hear only one side of the story, and employers can be cut out of the process altogether. But the other side cannot pass card check because once the American public found out about what they were trying to do, they objected. It took a little while because the card check legislation was deceptively named the Employee Free Choice Act, when in reality it would have forced employees into the exact opposite of a free choice. Any senator who opposes card check should also be voting for this resolution to stop ambush elections. Another reason the Congressional Review Act was designed for just this situation is that there is simply no other way we would be allowed to have a vote on this issue in the Senate. Back in December, the House of Representatives passed Chairman Klein's legislation that would have effectively killed the ambush election regulation and codify a 35-day waiting period before an election. The Workforce Democracy and Fairness Act was passed with bipartisan support, but it has no chance of being called up for a vote here in the Senate. So this vote is the one chance senators will have to stand up for employees and small businesses that want fairness. With any measure, the current law and certification system provides that fairness. The National Labor Relations Board keeps data on elections, timing, and sets up annual targets to process elections and decide complaints swiftly. Last year, they exceeded 2 of those targets and came within 0.3 of a percentage point to meeting the third. There is simply no justification for this regulation. Last year, initial elections in union representation elections were conducted on a median of 38 days after the filing of the petition. Almost 92% of all initial elections were conducted within 56 days of the filing of the petition. Not only are the vast majority of elections occurring in a timely fashion, but unions are winning more than ever. Unions win more than 71% of elections, their highest win rate on record. The current system does not disadvantage labor unions at all, but it does ensure that employees whose right it is to make the decision of whether or not to form a union have a full opportunity to hear from both sides about the ramifications of that decision. This resolution will preserve the fairness and swift resolution of claims which occur under current law. It will not disadvantage unions or roll back any rights. Let me repeat that. This resolution will not disadvantage unions or roll back any rights. What it will do is prevent the small business employers out in America from being ambushed and employees from being misled with insufficient information into union contracts that they cannot get out of. Under a successful Congressional Review Act disapproval, the agency in question is prohibited from issuing any substantially similar regulation. That means the National Labor Relations Board could not just reissue this regulation and could not finalize many of the other bad ideas they initially proposed. I will be speaking about some of those later on in this debate. Let's not wait for the courts to strike down this rule as they have the other NLRB's regulatory effort. That would be 2 out of 3 in the last 75 years. Now, with the President's appointment of the National Labor Relations Board when we really weren't in a Senate recess, the Senate didn't confirm the people pushing this, that were pushing this effort, but most of this was done under the previous people. So with the President's recess appointments in place, the Labor Relations Board is poised to push forward other bad ideas aimed at helping union bosses, not employees, not job creators. It's time to stop this agency and level the odds. I'm pleased to have 44 fellow senators co-sponsoring the resolution, and I will now yield time to other members who would like to speak in favor of it, first allowing the senator from Iowa, the chairman of the committee, an opportunity probably to speak against it. I yield the floor.
President.
Senator from Iowa is recognized.
President, I ask unanimous consent that Paul Edenfield, a member of my staff, be granted floor privileges for the duration of today's session.
Without objection.
Mr. President, by the way, I yield myself how much time I consume.
Without objection.
Mr. President, I also wanted to clear up one parliamentary question here. The document of the chair stated that we had 2 hours evenly divided. I believe that's today, but on the the agreement for the entire debate on the Congressional Review Act, if I'm not mistaken, is 4 hours evenly divided?
Senator is correct.
I thank the chair. Mr. President, this Congressional Review Act challenge is the latest chapter in an unprecedented Republican assault on unions. The amount of time this Congress has wasted scrutinizing and bullying the National Labor Relations Board over the last 2 years is simply astonishing. This time, the debate is about whether the NLRB acted appropriately when it streamlined its procedures for setting up a union election and eliminated unnecessary bureaucracy to make the agency more efficient. This seems like a common sense and logical step that, if taken by any other agency, my colleagues on both sides of the aisle would be applauding as a step forward for good government and efficiency. But because these reforms were put forward by the NLRB, an agency my Republican colleagues seem to want to do anything to undermine, we are all standing here today debating the merits of this eminently sensible action. It is a real shame. At a time we should be working together to rebuild our economy and address the real challenges facing working families across this nation. Republicans are instead distracting this body with partisan attacks on the National Labor Relations Board and on unions. Now, I would welcome the opportunity to spend this time on the Senate floor debating how to make life better for middle-class families. I would even welcome the opportunity to have a real debate about unions and the important role they play in our country. What I deeply regret is that we are instead going to spend time discussing the wild misinformation that has been spread about National Labor Relations Board rules that were properly undertaken, well within the agency's authority, and completely sensible. So let me take a moment to try to set the record straight. In December, after receiving public input, the NLRB announced that some internal agency procedures governing union elections would be changed. These are modest changes that not only make the procedures more rational and efficient, but also ensure that workers and employers alike will have an opportunity to make their voices heard in an environment free of intimidation. These changes, while modest, are desperately needed. They will address the rare but deeply troubling situation where an unscrupulous employer uses delay and frivolous litigation to try to keep workers from getting a fair election. Let me briefly explain how the process works and how the new rules will help. Ever since the passage of the National Labor Relations Act in 1935, workers have had a federally protected right to choose whether or not to form a union. And our national policy, as stated in that act, has been to encourage collective bargaining. Workers who are interested in forming a union can request an election if at least 30% of the workers in that workplace sign a petition and present that to the National Labor Relations Board. About 90% of the time, the employer and the union reach an agreement covering when the election will be held, the timing of it, and who is in the bargaining unit. That's the ideal situation. That's what happens the majority of the time. Although you'd never know it from the rhetoric surrounding these rules, the new procedures address only the roughly 10% of situations where these pre-election issues are in dispute. And the rules say nothing about 90% of the elections where the two parties reach a voluntary agreement on election terms. So this chart kind of shows us only a tiny fraction of election petitions will be affected by these rules. So as I said, 90% of the time, the proposed union and the employers reach an agreement. When the election is going to be held, how it's going to be held, and all that, they just voluntarily agree on that. Only 10% of the time do we have employers, some who are highly unscrupulous, who will do anything to prevent their workers from having any kind of a voice in the running of the facility. Then they go to extreme lengths to frustrate the will of those who want to form a union. So again, the rules that we're talking about don't even affect 90% of the business, will not even affect them. Now, this 10% of the time, when the parties can't reach an agreement, the NLRB then holds a hearing to decide who should be in the bargaining unit. The NLRB's proposed rules deal with the mechanics of that hearing, and they attempt to cut back on the frivolous litigation that has plagued the hearing process. That's the proposed rule. They deal with the mechanics of that, cut back on this frivolous litigation. Under the old rules, management could litigate every single issue they could imagine at the pre-election hearing. They could file post-hearing briefs over any issue, no matter how minor, could appeal any decision to the NLRB in Washington, here in Washington. In many cases, the election would be put on hold while the board reviewed the case. The workers then had to wait for the resolution of this litigation before they could even vote. When the management side took advantage of every opportunity for delay, the average time before workers could vote was 198 days. Again, we're talking about this 10% here. Talking about that. When management took advantage of every opportunity, the average time before workers could even vote was 198 days. And we have some cases where it's been as long as 13 years before employees were able to vote in a union election. Now, while the election process drags on, workers are often subjected to harassment, threats, and, yes, firing. A study by the Center for Economic and Policy Research found that among workers who openly advocate for a union during an election campaign, 1 in 5 is fired. 1 in 5 is fired. And you know what kind of signal that sends to the rest of the workers. A Cornell University study found that workers were required to attend an average of 10 anti-union meetings during work time before the election. Now, by law, workers have the right to organize. As I said, our official policy, as stated in the National Labor Relations Act, is to encourage collective bargaining. But in practice, we allow delay and intimidation to make that right meaningless. The current NLRB election reforms do not solve this problem entirely, but nevertheless they're an important step forward. They help clear the bureaucratic red tape that has wasted government resources and denied workers the right to a free choice. Under the new rules, employers and unions can still raise their concerns about the petition at a pre-election hearing, but they just can't play games to stall the election. For example, under the new rules, employers can't waste time before the election arguing over whether an individual worker is eligible to vote. That worker then can vote a provisional ballot, and the two sides can debate the issue after the election if it matters to the outcome, if it matters. What we've had in the past is, let's say if you had a proposed bargaining unit that was 200 people, let's say they got 100 of them to sign a petition. They usually try to get about 50%. They present it to the NLRB. Management then says, well, person A here shouldn't be in that bargaining unit because they're a supervisor. And person B over here shouldn't be in there because that person is really a clerk and not a handler, or whatever it might be that wouldn't correspond to the bargaining unit. Well, let's say they raise that issue on 5 people. Under the present situation, they could then take this to the NLRB, have hearings on each one of those, and then if they didn't like the outcome, they could then take it to court and drag it out. Under the new rules, what they would say is, okay, well, if management is challenging those 5 people, we'll set their ballots aside. We'll set it aside. And we'll have an election. Now, if the election was 150 to 20 that they form a union, then those 5 wouldn't make any difference one way or the other. But if the election were close and those 5 would, then the NLRB would step in then and say, well, now, wait a minute. Now we have to look at whether or not, and the election would be put on hold until they decided whether or not those people were rightfully in the bargaining unit to vote. So again, these are some of the games that have been going on. Another example is appeals. All parties still have the right to appeal any decision they disagree with, but now all appeals would be consolidated after the election. after the election, which allows the board to conserve its resources, keep the election process moving forward. These common-sense changes remove unnecessary delays from the process. They cut down on frivolous legal challenges and give workers the right to a fair up or down vote in a reasonable period of time. The new rules don't encourage unionization, and they don't discourage it. They just give workers the ability to say yes or no without having to wait several months or even years to do so. Now, there is rampant misinformation about this rule. To be clear, the rule does not allow a so-called ambush election where an employer is taken by surprise and has no ability or no opportunity to communicate with workers about the pros and cons of a union. As anyone who's ever been around a workplace that is part of an organizing drive would know, employers always know what's going on, and they have ample opportunity to express their views. They can require their workers to listen to an anti-union message all day long, every day, and that's perfectly legal, while the union isn't even allowed into the facility to talk to other workers. This rule also does not change the content of what an employer can or cannot say to its workers. It doesn't restrict an employer's free speech rights in any way. Finally, and I want to really make this clear, the rule does not mandate that elections be held within any particular time frame. For anyone who has actually read the new rules, it's clear that it does nothing of the sort. What these rules do accomplish is to help ensure that employers and employees have a level playing field, where corporate executives and rank-and-file workers alike have an equal chance to make their case for or against a union. Some workplaces will choose a union, some will not. But protecting the right of workers to make that choice brings some balance and fairness to the system. Indeed, many employers have recognized that the new rules are fair and balanced. Catholic Healthcare West, a healthcare company with 31,000 employees, filed comments stating that, quote, reforms proposed by the NLRB are not pro-union or pro-business, they are pro-modernization, end quote. And further, Catholic Healthcare West said they will, quote, modernize the representation election process by improving the board's current representation election procedures that result in unnecessary delays, allow unnecessary litigation, and fail to take advantage of modern communication technologies, end quote. Mr. Willie West, founder and owner of West Sheet Metal Company in Sterling, Virginia, wrote an article in The Hill newspaper stating that, quote, these seemingly minor changes certainly do not create uncertainty for me, and they will not affect my ability to create jobs. In fact, if the NLRB standardizes the election process, it seems to me this will reduce uncertainty and turmoil in the workplace, especially for small businesses. Especially for small businesses, end quote. Mr. West is exactly right. The rules are an improvement for small businesses and for those who want a cooperative relationship with their employees. Again, keep in mind, 90% of the time, have no problems. We're only talking about this 10% of the time. That's what these rules are aimed at. The new rules promote consistency among NLRB field offices. They simplify procedures for all parties, making it easier for businesses to plan. The old rules gave an advantage to the businesses with the most money and those most willing to manipulate the system to frustrate their employees' right to vote. Some of these businesses, in that 10%, could afford expensive lawyers to exploit the system and delay elections. The old rules worked well for anti-union law firms. I'll grant you that, but not for small businesses on a budget. By creating a fairer, more transparent process, the NLRB is leveling the playing field for small businesses. Most importantly, the rules also take a small step to level the playing field for ordinary Americans. The people who do the work in this country deserve a voice in the decisions that affect their families and their futures. Polls show that 53% of workers want representation in their workplace. 53%. But fewer than 7% of private sector workers are represented. And one of the reasons is the broken NLRB election system. Even though more workers than ever are expressing an interest in having a voice on the job, the number of union representation elections conducted by the NLRB declined by an astounding 60% between 1997 and 2009. When workers do file for NLRB elections, 35% give up in the face of extreme employer intimidation and withdraw from the election before a vote is even held. Let me repeat that. Workers have gone around, they've gotten signatures, they've gotten a requisite 30%, they usually get a lot more than that, 40 to 50%. They file with the NLRB. 1 out of every 3 of those give up in the face of extreme employer intimidation. Why? Because 1 out of every 5 is being fired. Being fired because there's no real penalty against the employer for firing someone for union organizing. Now, it's against the law to fire an employee because they were exercising their right to form a union, to be in union organizing. But it happens all the time. And why are employers don't worry about it? Because there's no penalties. The penalty is your back pay minus any offsets. I had a young man in Iowa, I remember very well, up in Mason City. He'd been involved in organizing a union at his workplace. He got fired. He filed with the NLRB, saying that he was wrongfully dismissed because of his union organizing activities. Well, they had a hearing, they had this. It drug on for 3 years. 3 years before the NLRB could reach a decision, and the decision was, yes, he was fired because of his union organizing activities. What was the penalty on the employer? They had to pay him 3 years back pay minus whatever he earned in the meantime as a worker. Well, how many people can go 3 years without working? Of course he had to work. So he had to go to work, and he had to show how much money he made in the meantime. That had to be deducted from what his employer had to pay him. The employer had to pay him practically nothing. And yet, using that as an example, able to frustrate the organizing of a union. So 1/3 give up in the face of extreme employer intimidation. Now, these are the problems that need to be addressed. It's not just a problem for unions either, but for our entire middle class and for the future of our economy. You know, if you take a look at what's happening to the middle class in America, it's being decimated. The American people are insisting, even though we're not doing much of it here in Washington, I can assure you, the American people have insisted that we have a national dialogue about the growing division between the haves and the have-nots in this country, about the detrimental impact that inequality is having on the standard of living of American middle-class families. This has led to important discussions about tax loopholes for corporations and millionaires. But as we've learned in battles from Wisconsin to Ohio and beyond, it's very much a conversation about workers' rights. Unions have always been the backbone of the American middle class since we started having a middle class. Since 1973, private sector unionization rates have declined from 34% of the labor force to 7%. From 1 out of every 3 workers in America belonging to a union to now only 7%, 1 in about 15. While unionization rates declined, so did the middle class share of national income. During some hearings that we had last year, we had a number of hearings on our committee about this. And when you track union membership, this is the blue line, from 1973 to today, and then you track the percent of workers covered by collective bargaining agreements, and then you track the middle class share of national income, look how they all go down the same. As unionization declined, the number of workers in collective bargaining declined, so did their share of the national income. That's what's happened to the middle class in America. Quite simply, The fate of America's unions parallels the fate of the American middle class. Unions are not a relic of a bygone era. They're a vital partner in a fair and successful 21st century economy. If we want to strengthen our economy and rebuild the middle class, we should be trying to figure out how to make unions stronger, how to get more people in collective bargaining, not attacking collective bargaining rights across the country. We should be fighting to ensure that every hardworking American has a right to be treated with dignity and respect on the job, and yes, to have a voice on that job. The current NLRB election reforms may fall short of that lofty goal, but as I said, they're an important step forward, and they deserve support. So I urge my colleagues to vote no on this Congressional Review Act challenge to NLRB's rules. Now that these rules are about to go into effect, I'm confident they will go into effect, it's time for this body to stop wasting time using the NLRB as an election year political football. These attacks on this modest rule, I think, go right after the intelligence of working Americans. These attacks want this body to stop. Stop. These attacks want us to make sure that somehow they're going to stop unions from being organized. But ordinary Americans and this middle class want us to stop this posturing, move forward on building an economy for the middle class, and yes, to support the right of people who want to form a union, to get rid of all of these delays, and to make sure that we have rules in place which basically reflect 90% of the employers in this country. 90% of the employers reach agreements with their employees on having an election. It's that 10%. That's what gets to be frustrating. And this is what this rules go after, is to make everybody sort of fall in the 90% so that we have a fair and expeditious and election process, one that is understandable, one that doesn't lead to all these frivolous litigations and delays. So we've got another couple, 3 hours of debate on this. After this is over with, I hope we can start focusing on ways to genuinely help the middle class in America. Mr. President, with that, I yield the floor.
Senator from Wyoming is recognized.
Now, most of the small business people that I know consider themselves to be part of the middle class, and I appreciate the statistics that the chairman provided, about 90% of the elections arriving at agreement prior to the election. I think what this rule is going to do is change it so that only 10% make agreement beforehand, because there's no incentive for the union to participate at all. They have the right to just take it over. And there were some statistics about unions and middle class, and kind of a myth that the current election procedures discourage unionization are the main cause of the private sector union decline. In the 1950s, private sector union membership reached its height of 35% unionized workforce. Today, there are less than 7% of the private sector workforce that is unionized. And the decline of unionization in the private sector can be attributed to several social, political, and economic factors, including present-day workplace laws at both the state and federal level have greatly improved working conditions, and a decline in the manufacturing base, and the new nature of employment where people are more transient in their careers, and the desire for contemporary employees to have a more cooperative relationship with their employer and vice versa. It's kind of a teamwork factor that most businesses have to operate on today. I think it was also said that employers have unfair access to employees and regularly bombard employees with anti-union propaganda. I think it was even said that it can happen 24 hours a day. The fact is, employer speech regarding unionization is closely monitored and regulated. For example, employers are restricted from visiting employees at their homes. inviting employees into certain areas of the workforce to discuss unionization, or to make promises or statements that could be construed as threatening, intimidating, or coercive. That's current law. Now, employers are required to provide unions with a list of employee names and home addresses for representation election purposes. I think it was also said that changes are needed because current procedures discourage employees from forming unions. Fact is, all employees have the guaranteed right to discuss their support of unionization and to persuade co-workers to do likewise while at work. The only restriction is that they not neglect their own work or interfere with the work of others when doing so. Employees, as well as unions, have the unlimited right to campaign in favor of unionization away from the workplace. The National Labor Relations Board election rule will postpone these legitimate questions after the representation election is held and could result in more post-election litigation. So there are a lot of factors that were mentioned. I'm not going to go into all of them. As I've stated throughout the debate, the National Labor Relations Board's ambush election rule is an attempt to stack the odds against American employers, particularly small businesses that don't have a specialist in that area or in-house counsel. Most small businesses that I know can't afford either of those. And they can be put into this situation of having to figure it all out in less than 10 days. And that's just to figure out the rules so that they don't get some heavy fines from the National Labor Relations Board. And that can be coupled with two other changes the administration is forcing. That's forcing some employers that will be caught in a perfect storm, taken together ambush elections, the National Labor Relations Board's micro-union decision, and the Department of Labor's proposed rule on persuader activity create a major shift in favor of organized labor. The Supreme Court has expressly stated that an employer's free speech rights to communicate his views to his employees is firmly established and cannot be infringed by a union or the board under the National Labor Relations Act. Yet the overarching goal of the National Labor Relations Board and the Labor Department's efforts is to put up barriers that can have the effect of limiting employer free speech. To get into the micro area, under the specialty health care decision permitting micro-unions, unions can now gerrymander a bargaining unit so that it's made up of a majority of employees who support the union. In this decision, the standard for whether a union's petition for bargaining unit is appropriate was not changed to make it very difficult for employers to prove it is not appropriate. The decision will lead to smaller units, which will be easier to organize and will cause fragmentation and discord in the workplace. Allowing micro-units will increase the number of bargaining units in the workplace. The result means that an employer could face multiple, simultaneous organizing campaigns, all with shortened election periods, thanks to this ambush rule. Those two combined would be pretty dangerous. Under the Department of Labor's proposed regulation to require increased reporting of persuader activity, an employer, especially a small employer, will rethink obtaining advice from lawyers or consultants on what to do when faced with union organizing campaign. Taking away the ability to consult outside parties, combined with a shortened election period, makes it nearly impossible for an employer to not only educate his employees, but to ensure his actions are within the law. Over 50 years, the Department of Labor has exempted from reporting requirements advice provided to employers. The proposed rule will significantly affect that definition. The complexities of the National Labor Relations Act almost require an employer to seek advice on what he's permitted to do or say to employees during a union election, especially if the election period is as short as 10 days. The proposed rule on persuader activity will chill employer speech to the point that employers will not seek and attorneys will not provide advice on any labor-related issue. So unions have turned to these regulatory initiatives after losing the public and political battle over the Employee Free Choice Act, otherwise known as card check. Organized labor's endgame remains the same, making it easier to organize by taking away the employer's free speech right and the employee's right to fair information. Supporters of organized labor have acknowledged that the winning strategy is to gain voluntary recognition in the union from employers instead of allowing employees to vote in a secret ballot election, despite a 71% win rate. Ambush elections, increased reporting on persuader activity, and the decision to allow micro-units will set the bar for an employer winning an election impossibly high, essentially coercing themselves into voluntarily recognizing the union. And I do thank the Senator for mentioning that 90% of the elections, there's an agreement before the election, done in a relatively short period of time, that takes care of all of the disputes. I don't know if the purpose of Congress is to make sure that 100% of situations never occur, or 90% or 99%, but everything can't be solved by doing a new rush-to-action regulation, particularly by an organization that doesn't do those regulations normally. In 75 years, there have only been 3 regulations. 2 of them were done by the Labor Relations Board in the last year, and one of those has already been set aside for the by the courts. So this is a rush-to-action situation, and I hope that you will join me in this resolution of disapproval under the Congressional Review Act. It's a very difficult bar to reach because the Senate will have to pass the resolution of disapproval twice with a majority of votes. That gives the other side the opportunity to see who might support it the first time and see if they can talk them out of it the second time. But after that, it has to go through the House, same procedure in the House. And this is the surprising part to me. If it passes both bodies, where both bodies have said, I don't think they're interpreting what we put in law, meaning Congress, who has are the only ones with the right to pass a law. What we put into law, they're trying to change. And that third step is that it requires the signature of the President in order for the Congressional Review Act to become effective. We're an equal branch of government to the administration. And the administration writes the rule. We disapprove of the rule because we say it doesn't follow the laws that we have already passed. And then the administration who wrote the law gets to say whether the votes of the people in the House and the Senate really have any effect at all. The Congressional Review Act has a definite place, but it should have been done using the authority of Congress itself, not the authority of the Congress and the administration combined. We're at a point where there's a heavy hand in the administration, and that will have a drastic effect on business in this country, and if business fails, there'll be less employees, not more. I yield the floor and suggest. Okay.
The majority has 36 minutes and 25 seconds.
Well, Mr. President, we're going to have a lot of time to flesh out some of these arguments again tomorrow when the vote gets near, but I thought I might just pick up on a couple or 3 things here that my good friend from Wyoming said, and he is my good friend. We do a lot of work together, and he's a great senator and a good friend of mine. He just happens to be wrong on this issue, that's all. But other than that, he's a good friend of mine. And this is the kind of good, healthy debates that we ought to be having on the Senate floor on policy. There's just a lot of talk about how this is going to, what do you call it, these ambush elections. Now we can have ambush elections and stuff. Well, that's just not so. The current median time between a petition is filed and when an election occurs is about 37 to 38 days. Now, again, I've heard from my friends saying that this could be ambush elections and all that kind of stuff, but even one of the nation's largest management side law firm disagrees. This is Jackson Lewis. One of their attorneys told the Wall Street Journal he thinks the time would be shaved to between 19 and 23 days under the proposal. Mr. Trauger, Vice President of the National Association of Manufacturers, said the elections would be held in 20 to 25 days under the new rule. So that's not an ambush election at all. All this rule does is just removes these extra legal hurdles that can cause excessive delays. Let's see, what else was it? Oh, yeah, we keep hearing about rulemaking and saying, well, you know, this board has only issued 3 of these rules in the past 75 years, 2 of these rules in the last couple of years. Makes it sound like the NLRB has ridden off the range here in terms of reasonableness. But the fact is that when the board promulgated rules in the past, they did it through the adjudicative process, not through rulemaking. The Supreme Court and the U.S. Courts of Appeals have criticized the board in the past for underutilizing its rulemaking authority. Courts have said that the rulemaking process is more transparent and more inclusive. So through rulemaking, this board has solicited broader public input in its decisions. So really what the NLRB has done in the last couple of years is it's opened up the process for comment periods and rulemaking through the Administrative Procedures Act, something that the courts have been asking and sort of advising the NLRB that they should have been doing all along rather than just relying upon the adjudicative process. So, yes, my friend may be right that 2 of the 3 in the last couple of years, but actually that's a move in the right direction. That's a move for transparency and openness and letting all different sides have their comments before they issue a final rule, rather than kind of doing it in the dark of the night, as maybe they've done in the past. Oh, yes, there was this quote about John Kennedy, about a 30-day waiting period. Well, I don't know. I haven't really looked at then Senator Kennedy's entire record. I suppose there are some things I might agree with him on and some things I probably wouldn't agree with him on. So I don't know what his thought processes were. All I can tell you is that no matter what he said at that time as a senator, the final bill did not have a waiting period. The Senate put it in. The House did not. When it went to conference, they dropped it. And so I think the rejection of that proposed amendment could be more reasonably understood as an indication that Congress did not believe a minimum time between petition and election is necessary. So, sure, you can quote Kennedy. Well, I guess I could quote President Dwight Eisenhower. And here's what he said: "Only a fool would try to deprive working men and women of the right to join a union of their choice." President Dwight D. Eisenhower. Well, we better not be trying to prevent them from joining a union of their choice. Now, I've also heard this charge that somehow these rules tilt this more in favor of the unions than management. Well, no, it doesn't. Now, again, we've mostly been talking about the certification process. When union organizers get the signatures, they file with the NLRB, and we have an NLRB process. Basically, that's what we're talking about here. But I would point out to my friend on the other side of the aisle that these procedures that we're talking about also applies to decertification elections as well. So since the same rules will apply to decertification elections, the proposed rule will ensure that employees who have union representation will be able to have a timely up or down vote to also get rid of the union. So to me, it's both. It's both on the certification, also on the decertification side. It just makes for things much more expeditious, much more clear, much more understandable. That's why I think many management firms and businesses see this as a reasonable rule, because they would then, and when they try to decertify, then they don't have to go through all this other frivolous litigation on the other side. So it applies both to certification and decertification, both. So it doesn't really tilt the playing field one way or the other. And again, I applaud the National Labor Relations Board for moving in the direction of more rulemaking, making it more open, making it more transparent than what they've done in the past. But you know what it really boils down to, I guess, Mr. President, is, you know, as long as I've been here, since 1985 in this body, we've had ups and downs on the National Labor Relations Board. And what really happens, I mean, let's face it, the National Labor Relations Board has 3 members from the President's political side of the party and 2 from the other side. So when you have a Democratic president in, then NLRB gets attacked by Republicans. When a Republican president is in, it gets attacked by Democrats. And it becomes just a kind of a political football. I understand that, and we should all understand that that's what this is too. That's what this is all about. Now, I just got notified of a statement of administration policy of what's called a SAP, Statement of Administration Policy, from the administration. It just came through, and it said that the president, even if this vote were held and the other side won, if it was voted to overrule the NLRB, that the president would veto it. And surely no one thinks there's 2/3 votes here to override the president's veto on this issue. So we're just kind of wasting our time here. It's sort of just another little political shot when there's so many important things that we should be talking about in terms of jobs, job creation, the economy, fair taxation, keeping our jobs from going overseas, education, job retraining. Yet we're spending our time talking about this. Well, be that as it may, the facts, I think, are on the side that this rule is eminently reasonable, fair, will lead to a more predictable, I think, and less litigious and less conflicting process when people want to form a union in this country. As I said, 90% of the time, we don't have these problems. But for those 10%, it can be devastating. And it can really thwart individual workers who want to form a union. So I'm hopeful that we can have a little bit more debate on this. I hope that the vote tomorrow will be conclusive and that we will turn this down and move ahead with more important business confronting this country. Are you?
Mr. President?
Senator from Wyoming.
We're having an interesting duel in statistics here.